be any business before this full court of the Northern Territory, now draw nigh and give your attendance, and you shall be heard. God save the Queen. Please be seated.
The court's welcome to His Honour Justice Graham Hiley.
Your Honour, the Administrator, the Honourable Sally Thomas, and Mr Duncan McNeill, who's not here, Attorney General John Elferink, the Lord Mayor of Darwin, Ms Katrina Fong Lim, Mayor of Palmerston, Mr Ian Abbott, former Administrator Mr Tom Pauling and Mrs Tessa Pauling, Mr John McRoberts, Commissioner of Police, Fire and Emergency Services, distinguished guests, members of the legal profession from both the Northern Territory and Queensland, family and friends of Graham Hiley, welcome. We gather for the presentation of the commission by His Honour Justice Hiley and to welcome His Honour to the court. I'm joined on the bench by judges of the court, Justice Southwood, Justice Kelly, Justice Blockland, Justice Barr, Justice Reeves, Justice Mansfield and Justice Mildren. I wish to extend a special and warm welcome to those who have joined us on the bench, being the distinguished former judges of this court, the Honourable Austin Ash and the Honourable David Angel.
Chief Justice, I have the honour of advising this court that I have been appointed a judge of this court by the Honourable Administrator, and I present my commission.
Thank you. I invite you to take your oath of office before Her Honour the Administrator.
I, Graham Eric Hiley, do swear that I will bear true allegiance to Her Majesty Queen Elizabeth II, her heirs and successors according to law, that I will well and truly serve her in the office of Judge of the Supreme Court of the Northern Territory of Australia, and I will do right in all manner of people according to law, without fear or favour, affection or ill will, so help me God.
Please take your seat, Justice Hiley.
Thank you, Chief Justice.
Master, would you please read the commission of His Honour?
To the Honourable Graham Eric Hiley. Know ye that, reposing full trust and confidence in your loyalty, learning, integrity and ability, I, Sally Gordon-Thomas, Member of the Order of Australia, Administrator of the Northern Territory of Australia, acting with the advice of the Executive Council of the Northern Territory of Australia, in pursuance of Section 32, subsection 1 of the Supreme Court Act 1979, do by this my commission appoint you, Graham Eric Hiley, one of Her Majesty's Council, learned in the law for the Northern Territory and the states of Queensland and Victoria, to be a judge of the Supreme Court of the Northern Territory of Australia from and including the 1st day of March in the year of our Lord 2013, to have, hold, exercise and enjoy the said office of Judge of the Supreme Court of the Northern Territory of Australia, under and subject to the provisions of the Supreme Court Act 1979 as amended from time to time, during good behaviour, with all rights, powers, privileges, advantages and jurisdiction thereto belonging or appertaining.
Master, please place the commission and the oath of office with the records of the court. Mr Attorney, do you move?
Dear Chief Justice, and may it please the Court, I rise today to heartily welcome the appointment of Justice Hiley to this most honourable court. It is traditional on these occasions to provide some account of Your Honour's early life and career as an introduction for those who are less familiar with your antecedents. In accordance with that tradition, I note that Your Honour was born in Sydney and completed your leaving certificate at Epping Boys High School. Your contemporaries at the school included golfer Jack Newton and that other famous Australian barrister, Geoffrey Robinson. Your Honour completed degrees in arts and law at Sydney University and then worked as a solicitor with the firm which subsequently became Mallison's. During that time, Your Honour also completed your national service as a legal officer with the Australian Army. Your Honour then came to Darwin in 1976 to work with local firm McCormack's. Following a stint with Cridlin and Bauer, Your Honour was called to the bar in 1978. Your Honour quickly established yourself as one of the Territory's leading barristers, and you were appointed Queen's Counsel in 1987. I think I can recall reading somewhere on Your Honour's website that this occurred a full 12 months before Geoffrey Robinson took silk. Although Your Honour may have won that particular race, I am reliably informed that Jack Newton, even with his significant disadvantage, has always been a far better golfer than yourself. Your Honour has a long-standing relationship with the Territory, and your appointment as one of its judges is a fitting culmination of that relationship. Your Honour had a wide-ranging practice at the bar, which included commercial causes, administrative law, personal injuries, criminal law and Aboriginal land work. The list of reported cases in which Your Honour appeared during your time in Darwin reads like a catalogue of Northern Territory precedent. Many of those cases remain the seminal authority in the relevant area inside Territory law. I will mention only a few which have particular significance in Territory legal history. Papandonicus and Telecom was a case in which started with a linesman falling off a ladder in Darwin, and it was a case which ended up revolutionising the law of occupiers' liability in Australia and ultimately in the common law world. Skews in the Commonwealth was a case which involved the notorious shooting of a lawyer in Alice Springs Courthouse, in what turned out to be a case of tragic mistaken identity. From those tragic circumstances came one of the more enduring assessments of the Commonwealth duty of care in public buildings. The Northern Territory of Australia and Mengle was a case involving the conduct of brucellosis and tuberculosis eradication campaign of the Northern Territory. It remains Australia's leading authority in relation to misfeasance in public office and overturned previous High Court authority in that respect, although I am reminded by the Crown that Your Honour was ultimately and properly on the wrong end of the result in that matter. As well as Your Honour's substantial caseload, you held office as President of the Northern Territory Law Society and subsequently as President of the Northern Territory Bar Association, and remained active in the Army Reserve for more than 20 years, ultimately achieving the rank of Lieutenant Colonel. You also served as Deputy Chairman of the Land Acquisition Tribunal for 12 years, Chairman of the Planning Appeals Committee for 10 years, Chairman of the Community Living Areas Tribunal for 8 years, and lectured part-time at the Northern Territory University for almost 10 years. From the mid-1990s, Your Honour enjoyed something of a reincarnation as a native title specialist, which coincided with a move to Brisbane for family reasons. In that capacity, Your Honour has been involved in most of the landmark cases in the field, and those in cases have included WIC, concerning the interaction between native title and pastoral leases, the various Yorta decisions concerning continuance of traditional laws and customs, Yarmir dealing with sea rights, the Blue Mud Bay case concerning rights in the intertidal zones, and RISC and the Northern Territory concerning the native title claim over the town of Darwin. Your Honour has also published widely in the field of native title, including editing the leading text on the issues and implications arising from the WIC case. For all Your Honour's achievements, you have always been and remain a modest and humble man. For many years you drove a rusty, bilious green Celica, which established beyond any doubt that you were entirely unconcerned with appearances. Your former juniors tell stories of you appearing before this in court, dressed variously in tracksuit pants, Daniel Boone-style jackets, and other clothing of that nature. In fact, the common perception is that your honour is practically Amish in your attitudes to dress. Of course, less charitable colleagues have attributed your honour's plain taste in motor vehicles and clothing to a grim and Scottish determination not to part with money except in the cases of the most dire and desperate emergencies. Naturally, I rebuke them for their lack of charity. Your honour also has a reputation as a prankster. One of those pranks involved, rather unwisely as it turns out, concreting a garden gnome into the front yard of a colleague. As is the case with many pranksters, Fortuna made certain that your colleague was later to be appointed Chief Justice with control over this court's court. All this experience and these attributes equip your honour well for your new role. And the people of the Northern Territory, rightly and properly, have certain expectations of their judicial officers. So consequently, your honour, and with all levity aside, I come before you to enter a plea on behalf of the Queen and her people who reside here in the Northern Territory. As part of the contract that you enter into by accepting your position, you are unencumbered by the unlawful influence that both the Executive and the Parliament, or that matter, any other agency can bring to bear upon you. This is a fundamental precept of our system. It now becomes essentially impossible for any to touch you other than in the most extreme circumstances. And there are only two restraints which may be imposed. The first restraint is that of your equally independent peers and seniors in this court and the Superior Court. And I will not expand on that. But the second, however, is the restraint of your own integrity. It is your reputation, your skills, your experience and your integrity that have seen this trust bestowed upon you. There should be no better guide for you than your own conscience, no better compass than your own sense of justice and your knowledge of the law. I plead before you to fulfil the terms of your contract with the people of the Northern Territory with all the integrity, justice and wisdom that lies within the realm of your power and your understanding. For all of the concrete and steel that makes this splendid building, it is but gossamer and flotsam next to the true fibre of this place, your integrity and the integrity of your peers on the bench. It is that fibre that prevents the roof calamitously falling upon all of our heads. In truth, Your Honour, I believe this pleading is not at all necessary, as I am certain you would not have it otherwise. But this is a sacred trust, and consequently I cannot forbear but to mention it. It is a deep duty that we the people demand of you, a demand I am utterly confident that you will embrace with all solemnity, dignity and reverence. Judge wisely, Judge. May it please the Court.
Thank you, Mr. Attorney. Mr. President of the Northern Territory Bar Association, do you move?
Yes, may it please the Court. Firstly, on behalf of the Northern Territory Bar Association, I offer to Your Honour Justice Hiley our congratulations and best wishes on your richly deserved appointment. Further, we, the Bar Association, welcome you back to this jurisdiction of the Northern Territory, a jurisdiction the likes of which there is no other in the common law world. Our jurisdiction boasts a singular jurisprudence, rich in creativity and inclusiveness, being important hallmarks and attributes of any common law system. It was, of course, a jurisdiction in which Your Honour revelled as a barrister here in Darwin from the years 78 through to 93. The learned Attorney General has taken us to your significant works and contributions to the Territory legal system then, and in particular, he mentioned your representative capacity as both President of the Northern Territory Law Society, which was from 87 to 88, and indeed as President of this auspicious body, the Northern Territory Bar Association, which lasted from 1990 to your departure from the Territory in 93. Briefly, and I'm indebted to the learned Attorney General for touching on some cases, and forgive me for mentioning them again because it merits, the occasion merits it. You were a solicitor from 76 to 78 here in Darwin, and then you joined the newly formed independent bar. In fact, you were one of the founding fathers in 1980-81 of this, and again I stress, most auspicious body, the Northern Territory Bar Association. of which I now have the privilege and great honour of being its president. Having been appointed Silk in 1987, you operated at the apex of your profession. You deservedly enjoyed respect and regard from the profession itself, not only from your instructing solicitors and your fellow barristers on the roll, but also the bench, who held you in high regard for your learning, your integrity, and even-handed yet determined advocacy. Further, and personally, it should be said on this occasion that you were universally liked by the profession and the court staff. This fondness came by virtue of your decency, courtesy, your sense of humour, and your self-effacing manner. Significantly, you are still fondly remembered by many in the profession through the fact that you were approachable and extremely helpful to the junior ranks of the profession. And I myself count myself as a member of that club. You enjoyed, of course, a very broad and busy practice as a silk in the mercantile killing fields of both commercial and civil litigation. Cases have been mentioned: the Northern Territory of Australia against Mengo, which is to be found at 1994, 185 Commonwealth Law Reports at page 307, known more popularly as the Banka case, which was in relation to the BTEC programme, and you represented the Mengo family throughout that extensive litigation, ending in the High Court of Australia. Further, and it's been mentioned, Papantonakis against Australian Telecommunication Commission, reported in 1995, 156 Commonwealth Law Reports at page 7. You and the present Chief Justice were at the fulcrum in many respects of those civil litigations going on in that period. The Hiley, Riley, Ding Dong was a feature in those mercantile and litigation killing fields. Some of us will remember, and he's passed away now, the court orderly Steve Durant, God rest his soul, who is often heard muttering in the corridors of the Supreme Court when trying to find counsel, "Hiley, Riley, Smiley, don't ask me." Of course, you recently appeared, and it's been mentioned again, in the famous native title cases, Yorta Yorta, Wick. And so in 1993, it was the Territory's loss and Queensland's gain, just as now it's their loss and our gain, that you left our jurisdiction and, to quote the poet, went to Queensland droving. But of course we did know where you were. We of course know that you spent the majority of the last 20 years practicing successfully as a barrister in many important and leading native title claims. Indeed, much of your work in Queensland has been involved in this dynamic area of native title claims made by Indigenous peoples, flowing from the historic High Court decision of Mabo and the resulting federal and state legislation. This deep and close involvement with Indigenous peoples, their language, customs and laws will serve your honour well in dispensing justice in this honourable court. The Territory legal system has prided itself on its abilities over decades to address, consider, and not only acknowledge Aboriginal customary law, but when appropriate, accommodate the same into our mainstream common law, that which originated from the English legal system and the English common law. And it is by this process of development, as only the common law does and can develop, that the Territory is able to boast such a rich, varied and impressive jurisprudence. However, we live in present times when both federal and Territory executive governments have legislated to now severely restrict and in some areas exclude such an accommodation. This is seen in the court sentencing exercise in criminal law when, although clearly relevant to a sentencing judge, evidence of Aboriginal customary law is prescribed to have no effect in the sentencing exercise. Having a jurist learned in the intricacies and nuances of such customary law will be a great addition to this honourable court. And so, my task here on behalf of the Bar Association and indeed the legal profession is to welcome you back to this court. Nevertheless, in welcoming your honour, I have to point out that things have changed since you were last here. Seriously changed. Some might say you were here in the halcyon days in '93. And I think we should go back there, albeit briefly, just to remind ourselves of how things have changed, for your honour's benefit, if nothing else. Marshal Perrin was the Chief Minister. The Right Honourable Austin Ash finished his term as Chief Justice to be replaced by the Honourable Brian Frank Martin as Chief Justice. Tom Pauling QC was the Solicitor General. Sir William Carney was still a judge of this honourable court. Nationally, Paul Keating won the unwinnable election in March 1993. As it happened, it was the International Year of Indigenous Peoples. Mandawai Yinipingu, a Territorian, was the Australian of the Year, and that year flowered probably at the MCG in September, when Essendon belted Carlton in the grand final. And not only did our Michael Long take out the Norm Smith medal, but Gavin Wanganeen won the Brownlow. Mr. Tippett's looking a bit ill then at that last stage. Indeed, halcyon days. Mandatory sentencing was 3 years away and beyond most people's wildest imaginations. Again, I stress, things were different. Now, in my extensive research in relation to this presentation, conscious of your honour's pivotal role as a founding father of the Northern Territory Bar Association, I've researched as deep as I could with the able assistance of my learned Vice President, Mr. Weigel, and I've obtained through those researches relevant minutes of the Northern Territory Bar Association meetings. And those minutes share a very telling light on the way things have changed, and arguably for the worse, Your Honour. First of all, if I can take you to, as I've mentioned earlier, you were indeed a founding father of our auspicious organisation. And the minutes duly record saying, the inaugural meeting, 27th of June 1980, Mr. Pauling took the minutes. Those minutes record that Mr. Maurice QC was elected unanimously without opposition as President, and your good self, Your Honour, was voted as the Treasurer. We pursued these minutes as best we could, and I must say they were rather scant and difficult to come by. However, I was able to find some from the mid-80s which shed a light on the way, sadly, I have to advise Your Honour, that things have changed. Minutes of the Northern Territory Bar Association, meeting held on the 6th of August. Present, T. Riley, J. Reeves, G. Hiley, P. Brasher, P. Tiffin. Now, the minutes are relatively short, but the thing I want to stress about these minutes is that they reflect, the priority given in these minutes really reflect back then how the bar worked and the Bar Association worked, and I'm afraid to say things have changed in that regard. There are 3 items on the minutes for that important meeting. First was the Council for Law reporting, which tells us that Mr. Tiffin was to be the bar's rep, and he was to notify the Department of Law. The second is the bar rules, which were incorporated and accepted and voted in. Then we have the all-important minute, which takes up the vast majority of the recording of that important meeting. It's entitled Social. J-A, J-R, G-H and P-B to draw up a social calendar to include the following, and I stress to include. So don't think that was the end of it. Here we go. A. Bar luncheons. To be held on the last Friday of every second month, commencing the 30th of August. B. Bar and bench dinners. Wait for it. 4 per annum, 2 to include spouses. Attorney General to be invited to this dinner. He goes on. C. Drinks. Believe it or not. Drinks at Chambers from 4:30 to 6:30 p.m. on the 1st, and third Fridays of the month. To include invited solicitors, judges and magistrates. Now, we've got D. Alice Springs. When 3 or more are gathered. Actually, they probably sort of fell off the Darwin circuit. Looking for some respite. There's another 2 colleagues. Guess what? Put on drinks for the Alice Springs solicitor. Now, we've got an E and an F, and it probably should be mentioned, but it was the farewell then to Acting Chief Justice Muirhead. So, what did that arrange? You bet, dinner. And also a last mention of federal court judges. And guess what that involved? Drinks at Chambers, 20th of August at 5 p.m. Now, that impressed me no end. That missed out big time. I don't know how you guys did it quite frankly, but you did. But there's a telling feature here because I've continued my in-depth research of these minutes. And the next record I find, again, the minute recorder is Mr. Polling, NQC. The next recording is, then there are 2 years of minutes missing. Via Alice Springs, federal judge here, and former Justice Muirhead. So, I think that's an accurate reflection, and perhaps a good way of showing to Your Honour, albeit sadly, that things have changed somewhat compared with back then. However, today is a genuine celebration, and we celebrate today, and again I repeat on behalf of the Association, heartfelt congratulations and a genuine welcome back to this jurisdiction. But please the Court.
Thank you, Mr. President. Madam President of the Northern Territory Law Society, do you move?
Thank you, Your Honours. As I've said before, Mr. Lawrence is a very hard act to follow. It is with great pleasure that I get this opportunity to stand before you today on behalf of the Law Society and the legal profession of the Northern Territory to welcome Your Honour, Justice Graham Hiley with an H, to the Supreme Court bench of the Northern Territory. I gazump the Chief Justice here because he's told this story before, following on from Mr. Lawrence's Hiley, Riley, Smiley, who cares antidote. Although our Chief Justice has the Chief in front of his Justice, Your Honour, Justice Hiley was made silk before Justice Riley, and in fact was the one to advise him before the attorney got to ring him, because they that it was the attorney at that time rang you by mistake to advise you to give it silk. I thank His Honour the Chief Justice for that bit of information. As a third speaker, Your Honour, I'm trying to avoid the repetitions. It is clear Your Honour has had an illustrious career as a barrister of both the Northern Territory and in Queensland. But in terms of the Law Society, we've been able to do a little bit of research, not as extensive as Mr. Lawrence. Your Honour arrived in Darwin in 1976. You commenced working as a solicitor at McCormack & Co. And then moved to Cribbin Bowers Solicitors in the Northern Territory. You were admitted to as a barrister of the and solicitor of the Supreme Court in 1976. And you, as we've heard, was called to the independent bar in 1978. Despite leaving the Territory in 1994, Your Honour, you were kind enough to maintain membership of the Society from 1976 through to 2000. You then clearly faded away a little bit, but we are very grateful that you've rejoined us in 2012. Your Honour was, of course, a founding member of the Anti-Bar Association in 1981. And Your Honour, it hasn't changed that much. The bar still have drinks on Friday afternoon. I'm not sure which bar Mr. Lawrence was referring to. From 1979 to 1984, Your Honour was the chairman of the Society's Professional Indemnity Insurance Committee. You were vice president in 1986 to 1987 and became president from 1987 to 1988. As the president of the Law Society during that time, Your Honour was also the Society's delegate to the Law Council of Australia. During the time of your presidency, Your Honour, the Public Purposes Trust in the Northern Territory was launched. The purpose of that trust was to advance legal education and improve access to legal services. Also during your year as President, Your Honour, there was a number of reforms of the Society, and a few of those included keeping the posts of immediate past presidents. Unfortunately, that's changed now too. That's gone now again. There was monthly meetings between the Chief Justice of the Society and the Bar Association, and there was also a standard form Law Society contract, which Your Honour, as the President, encourages use during those times. Your Honour, also, as during your year as President, saw submissions on proposed amendments to the MT Planning Act at that time, the Liquor Act, the Evidence Act and the Police Administration Act. During 1988, the Supreme Court rules came into force, and we also note at the Law Society Your Honour's dubious honour by virtue of your membership of the Ethics Committee that you were named as a defendant in the Supreme Court matter of Shane Stone, Graham Hiley, John Stewart and Kim Graves in their capacity as members of the Ethics Committee. Unfortunately, on appeal, the findings of the committee on that matter was quashed. Your Honour's experience with Aboriginal land claims commenced in 1978 when you were counsel assisting the first Aboriginal Land Commissioner, Justice Tui. Your Honours has since, of course, appeared in numerous land claims in various capacities. I've just grabbed up half my page because Mr Lawrence and Mr Attorney has kindly listed Your Honour's attributes and success in that area. Your Honour has also published widely in native title matters, and in 2006 Your Honour became editorial board member of the NT Law Journal. Lastly, but certainly not the least, Your Honour, I do note, not in terms of golf, but Your Honour's significant contribution to the annual cricket match between the Chief Justice's 11 and the President's 11 in 2012, Your Honour. Your Honour was kind enough to agree to play on my team on that occasion, and of course we thought that we had acquired a great cricketer in Your Honour's agreement to play for my team, and indeed it was a privilege to witness Your Honour's great cricket prowess during the game. Your Honour will be a great loss to the Law Society's team and a great gain to his Honour Chief Justice team, no doubt, given that you will no doubt be seconded to his Honour's team for the annual match on the 19th of May this year, Your Honour. I will just have to contend with the loss of Your Honour's contribution to my team, especially in light of the fact that Your Honour suffered an unfortunate injury during the practice leading up to the match and didn't in fact get to bowl or bat on that occasion, and that's probably why my team lost by a mere 9 runs, as the Chief Justice keeps reminding me. Your Honour, you have excelled in your legal career to date. We are sure that you will bring to your role in the court your excellence that you've demonstrated so far, and we wish Your Honour the very best on the bench. May it please the Court.
Thank you, Madam President. Mr Douglas, representing the Queensland Bar Association, do you move?
May it please the Court. Suffice it to say, occasions like this are important, and that's not just so for Your Honour, for your family and also for the Court. They are also important to members of the public who have resorted to the Court as litigants and who are affected by the decisions of this Court under the rule of law. The public are entitled to attend occasions like this or read a record of what is said in the media so they can judge for themselves whether a new judge, by character traits of learning, temperament and personality, is suited to judicial appointment. And that is so by hearing today from those who know the appointee and who, I might add, are required by ethical obligation of candour to speak the truth. The truth I speak. Any member of the public Justice Hiley can leave this place today confident that Your Honour harbours, and in good measure, all of the necessary traits for judicial appointment. My specific task here today, though, with the leave of the Chief Justice, is to speak on behalf of your Queensland colleagues. I've been asked by Roger Traves, Senior Counsel, President of the Bar Association of Queensland, and the members of the Council of the Association to offer their congratulations to Your Honour, and I do so, and I'm happy to do so. You are held in the highest regard by your fellow Queensland barristers, and there is no better evidence of that regard than the presence here today of most of your chamber colleagues from Jeddah Chambers in Brisbane, together with a goodly number of your former briefing solicitors. They've travelled here today to honour you. They expect, and I think thus far they've met their expectation, they expect entertainment here today and also this evening. Many from Queensland have asked me to pass on to you their regards. You and your wife Sue made many friends in Queensland, both in legal and non-legal circles, since you moved there in 1994. A number of judges and tribunal members, state and federal, have asked me to pass on their regards to you on this occasion. They pass on their appreciation for your determined yet even-handed style of advocacy. There were no Delphic submissions from Your Honour. They always knew where you were coming from. Mr Graham Neate, President of the National Native Title Tribunal, has asked me to pass on his congratulations. He can't be here today, as you know, although he would have liked to have been. Mr Neate, whose admission you moved in this court in 1981, waxed lyrical of your influence in the development of native title law and practice in the many native title cases you argued. He referred also to claims of which you were instrumental in the settlement of, including the West Geelong claim in North Queensland and the Quandamooka claim to North Stradbroke Island, which was finalised by consent determination in July 2011. Finally, Mr Neate spoke of the work you did with Dr Ken Levy on the Native Title Claims Resolution Service of 2006. That has been relied upon by successive Australian governments in preparing amendments to the Commonwealth Native Title Act in 2007 and again in 2009. And it underpins a number of the institutional reforms made in 2012, coupled with the amendments to the President of the Parliament. Your Honour, many of your non-legal friends in Brisbane pass on their regards. In particular, your poker group say they'll miss fleecing you at the fortnightly card nights. To allay the fears of the public in that regard, those gentlemen were at pains to point out that the only true lack of liquidity in the group lay in the empty bottles at the end of the evening at each poker night. Your Honour, we congratulate you. We commend your appointment. We hope to maintain our friendship with you despite your move from what used to be called the Sunshine State. May it please the Court.
Thank you, Mr Douglas. Justice Hiley, do you wish to respond?
Your Honour, the Administrator, Chief Justice, Attorney General, judges and former judges of this honourable court, distinguished guests, fellow members of the legal profession, family and friends, ladies and gentlemen. I was going to offer drinks to everybody after we finished, but in light of the admonition of Mr Lawrence, I'm sorry, I can't do it. Thank you all for honouring me and this court for attending this afternoon. Thank you especially to those 30 or so friends and family who have travelled here from Brisbane, Sydney, Melbourne, Adelaide, Newcastle and Singapore. Thank you to the many members of the profession and other personal friends who have taken the time to come along to witness my swearing in. And thank you to all of those here who I do not know so well. They include members of government, the military forces and the police. Your presence here reflects the respect which the parliamentary and executive arms of government have for this judicial arm of government and recognises the important function of the rule of law in this lucky country. Thank you too, Mr Attorney, Mr Lawrence, Ms Cheong and Mr Douglas for your kind and thoughtful words. I know how long it takes to research and prepare a speech for occasions such as this, and I appreciate you having done so on this occasion. I also appreciate and thank the many people who have sent me letters, cards, emails and who have telephoned me with generous messages of congratulations, support and encouragement. I have many people to thank for their contributions towards this very important stage of my life. And of course the foundation to my happy and fortunate life is my parents. Together they struggled to support my brother and me through school and university, and by their example, Mum and Dad showed us the need to set goals and to work hard to achieve them. And they instilled in us many fine and Christian values which I know will be of much assistance to me in my new role as a judge. Unfortunately, my father is not here as he passed away some 18 months ago. He was always supportive of me, particularly during my years at university and during my time in the army doing national service. However, I am honoured by the fact that my 91-year-old mother has been able to make another trip to Darwin, especially at this time of year for this occasion. I thank for their contributions to my fortunate life my brother Peter, my dear wife Susan, my 4 wonderful children, Nicole, George, Catherine and Michael, all born in Darwin and each setting and achieving their own special goals and livelihoods in various places in Australia. Shortly after we were married, Susan and I set off for a 6-month drive around Australia in a Land Rover. Little did we expect that we would find ourselves marooned in Darwin in March 1976 and end up staying here for the next 18 years or so, during which time we would have 4 fine children, we would establish a happy home life and a successful work life. Nor did either of us have any inkling of the fact that we would be back here now. Thank you, Susan, for your continuing love, support and encouragement during our 38 or so years that we have been together. Thank you too, Nicole, George, Catherine and Michael, for your loyalty, support, love and understanding, especially during those times during a trial when, as Susan would warn you, watch out for Dad, he's in court mode this week. During our early years in Darwin, we were fortunate to meet and participate in activities with lots of other friends, many of whom are here. We got to know well the likes of the Bradleys, the Rileys, the Winters, the Mansfields, the Whartons, the Coolahans, all of whom have been kind enough to come along today. Living and practising law in the Northern Territory provided me, and I know provides others, with wonderful opportunities, and these are opportunities that we may or probably would not have had elsewhere. As a young solicitor, particularly at Cridlin and Bower, I found myself frequently going to court, appearing in not only Magistrates Court but also the Supreme Court. That was an opportunity probably unique to the Northern Territory, that as a very young solicitor you'd find yourself appearing in the Supreme Court. I joined the fledgling independent bar in February 1978, and as has been noted, there were 3 of us there then, Michael Maurice, John Harrison and myself. The bar had previously been set up and Ian Barker QC had left the bar to become Solicitor General Tom Pauling had gone to become an acting magistrate. From the outset, I received strong support from the Northern Territory legal profession. Indeed, my very first brief at the bar was from one Trevor, who was then a partner at Ward Keller. I've been checking my notes, but I still don't think my paltry fee on brief of $75 has yet been paid. The growing local bar has always received the support and encouragement from the judiciary, particularly Sir William Foster and James Muirhead. They were great days, and the range of work was, and I'm sure remains, varied and challenging. Since I began practising here in 1976, there have been many substantial changes to the law, resulting in fascinating and challenging work for the Northern Territory legal profession. These have included the statutory conferral of Aboriginal land rights in 1976 under the Commonwealth Act, the Aboriginal Land Rights Act. Self-government in 1978, giving us young lawyers wonderful experience and exposure to constitutional law. The removal of common law remedies in relation to motor vehicle accidents in 1979, and the removal of common law remedies in relation to industrial accidents in 1986, and of course the codification of the criminal law in 1984. Needless to say, those of us practising law during those times were able to participate in numerous novel cases that arose and that had to be considered and determined by the Northern Territory courts and other tribunals. In those days, and no doubt still, virtually every case presented a new challenge and thus made life at the bar exciting and satisfying. Perhaps the most significant opportunity that I ever had was to serve as counsel assisting the Aboriginal Land Commissioner, Justice Toohey. As we know, was then a Supreme Court judge of this court and went on to be a High Court Justice and participated in the Mabo case, amongst many others. I was privileged to be his counsel assisting in a number of the early land claims under the Land Rights Act. My first land claim in 1978 was the Wallaby land claim. This required us to travel and stay at Largemanu and Yuendamu and to sit in various locations, including under gum trees and in dry creek beds. Then followed many other land claims, often in Central Australia region, also involving staying and sitting in remote communities in many parts of the Northern Territory. In fact, I still recall us sitting at a place called Utopia, which is certainly nothing like Utopia, and the lack of beds was such that I had to sleep in the medical unit there on the one and only bed. And I was rudely awoken at 2 o'clock in the morning when apparently an Aboriginal woman was about to have birth, so I had to relinquish the bed in the medical unit to enable that to happen. Such was life in the Territory and the exciting times that it produced. My wife Susan often speaks of the day when we brought our firstborn Nicole home from the old Darwin hospital, only to have me set off 2 hours later for Ayers Rock with Justice Toohey for the Ayers Rock land claim. I stopped doing land claim work in about 1982. I decided that I should be spending more time in Darwin with my young and growing family, and that I should devote more of my early days at the bar to more mainstream areas, which I did until the mid-90s. But my early land claim experience inspired and equipped me to participate some 15 years later in the developing jurisprudence of native title in the federal court. My native title practice began in the 90s, in the mid-90s, and remained a substantial part of my professional focus of my life for the following years. Indeed, one disappointment about taking up my new position at this time is that I've had to relinquish a very interesting case in South Australia, part heard before Justice Mansfield, who has honoured me and this court by attending today. I have been following with great interest and concern the ongoing endeavours to improve the lives of Indigenous people, many of whom live in the Northern Territory. I'm particularly saddened by the fact that the plight of many Indigenous people appears worse today than what it was one or more generations ago, certainly worse today than it was when I was practising in the Northern Territory previously. This is the case notwithstanding the grant of land titles under the Land Rights Act since 1976, the recognition of native title under the Native Title Act in 1994, inquiries such as the Aboriginal Deaths in Custody Royal Commission, and the Northern Territory intervention by the Commonwealth Government. I've also been reading some of the discussion in the media about sentencing of Indigenous juveniles, not only here, but also elsewhere in this country. And I note the frustration expressed by judicial officers, particularly magistrates, about their sentencing options and limitations. Whilst I recognise that the resolution of many of these issues is beyond the power and jurisdiction of the courts, I'm conscious of the fact that the courts do have a major role to play when dealing with offences, particularly where aspects of traditional Aboriginal law or custom are present. In this regard, I note that as long ago as the early 1950s, the Northern Territory Supreme Court was confronted with the intersection between traditional Aboriginal law and custom and the criminal law. For example, whether a certain accused could be convicted of murder for killing another Aboriginal man, having been ordered to do so by his Aboriginal elders. The man that he had killed had committed a very, very serious crime according to Aboriginal law, and so that question came up whether or not that would provide some sort of defence to murder, and as we know, it didn't and doesn't. Secondly, again, another decision in the early 50s, whether and how the court should take into account during the sentencing process the fact that an accused would also be punished under Aboriginal law for the same offence. I'm also very much aware of the current debates about mandatory sentencing, the adequacy of facilities for rehabilitation and for the mentally ill in the Northern Territory, and the sufficiency of funding for legal aid. Sadly, I suspect that much of my work will be involved in the criminal jurisdiction and will continue to involve crimes inflicted upon vulnerable people, such as innocent women and children, in circumstances involving drugs and alcohol. I recently revisited some of the old judgments of this court and reminded myself of some of its history from parts of Justice Mildren's excellent book, Big Boss Fella All Same Judge, published in 2011, 100 years after this court began. In the early days, the remoteness of the territory from the rest of Australia was largely responsible for many unusual things happening that hopefully would never happen again within the Northern Territory legal system. These included the need for the judge to travel by boat all the way around from Adelaide in order to hear and determine cases. The holding of a public meeting near the administrator's office in Darwin that led to the judge and the administrator being run out of town, followed by the judge's dismissal from office. Thirdly, the need for a judge's decisions to be retrospectively validated because of the invalidity of that judge's appointment. Fourthly, the appointment of a judge whose practising certificate had previously been suspended. Fifthly, a judge refusing to allow an Aboriginal accused an interpreter during a trial. And finally, the abolition of trial by jury, a situation that pertained for many decades. They were many years ago, and of course the profession and the court has moved on from those early days. Of course, in later years, the Territory was blessed with a number of excellent judges, such as Justices Queensland and Blackburn, who considerably enhanced the skills and reputation of the court. Following them, the likes of Justices Foster, Ward, Muirhead, Toohey, Gallup, Carney, Ash, Thomas, Angel, Martin, two Martins, Mildred, and those who I'm now joining, have ensured that this court is one that fairly and competently performs the functions expected of all superior courts in this day and age. I'm proud and privileged to be given this opportunity of joining the court and meeting the ongoing challenges involved in the provision of justice to the Northern Territory community. I'll do my best to fulfil my promise to serve the community in the exercise of the important powers conferred upon me as a member of the court. I'm pleased to be joining your honours on this bench. I've known each of you for many years, both socially and professionally, and I have the utmost respect for your respective abilities and enthusiasm. I'm also aware of the hard work done by others involved in the Territory justice system, including the magistrates, the Crown, the DPP, legal aid, the police, and of course the legal profession. I look forward to joining such a fine group of people and playing my part in maintaining the integrity and high standards set by them. Thank you to all of those who I've met and worked with here in the Territory. Special thanks to the many solicitors who have briefed me over the years, the many barristers with and against whom I've worked. In particular, thank you to the members of my old chambers, William Foster Chambers, for your company and support over the years. I'm proud to see that the fledgling Northern Territory Bar of 3 that existed when I started in '78 has grown to over 30 members, spread over 5 sets of chambers. Thanks too to those with whom I've been working in more recent years in Brisbane and elsewhere in Australia. These include my fellow barristers at Jet Art Chambers and other Brisbane lawyers and friends, some 12 of whom have honoured me in this office by travelling here to attend this occasion. Thank you also to my family and other friends, many of whom are not lawyers, for your friendship and company. I'll continue to look to you all for your support in my new position as I endeavour to serve the community in accordance with the oath that I have taken. In particular, I aim to remain conscious of the need for the legal system to recognise and protect the rights and responsibilities of all Territorians, many of whom are nowhere near as fortunate as I have been.
Thank you, Justice Hiley. Mr Solicitor, do you move?
May it please the court.
Mr Kraszewski, do you move?
May it please the court.
Mr Tippett, do you move?
May it please the court.
Ms Cox, do you move?
May it please the court.
Mr Wyville, do you move?
May it please the court.
Mr Dan, do you move?
May it please the court.
Are there any other motions from the bar? Thank you. Well, ladies and gentlemen, that concludes this special sitting. I think it is appropriate that we have a photographic record of this occasion, and I invite those who are robed and those who are advocates before this court to now join Justice Hiley on the steps of the court for a photograph. The judges will be pleased, and this is not Justice Hiley's shout. If it was, it would be the first. The judges will be pleased if you would all join us in the foyer of the Supreme Court for refreshments following the adjournment. Would you please now adjourn the court?
Some of the court now stands. God save the Queen.